everyone. This is Making the Case. I'm Laverne McGee in for Yodit. It is week 2 of jury selection in the trial of the men accused of killing Ahmaud Arbery. The week is over, but the jury panel is certainly not set, and this process appears far from over. So here's what happened so far. Close to 50 prospective jurors have advanced to what will be an initial pool of 64. From that pool, then they'll choose a final 12 plus 4 alternates. But today, things appeared to grind to a halt, with the strike being the theme of today's sessions. BNC's Drake Clark is outside the courthouse in Brunswick, Georgia, to explain.
There's no question the jury selection process in this trial has been unusually slow. The prospective jurors are getting frustrated, the attorneys inside the courtroom are getting tired, and the judge is saying that he's trying to move the process along as fast as he can, but also saying this is not the kind of trial he can simply rush through. Everyone knew the murder trial for Greg and Travis McMichael and William Bryan would be challenging. The biggest challenge, selecting a fair and impartial jury. 1,000 people in Glenn County, Georgia, where the trial is being held, received a summons to appear for jury duty. Many of the potential jurors know the defendants on a first-name basis, and almost all of the potential jurors have heard the name Ahmaud Arbery and seen the cell phone video of him being shot and killed at the hands of the McMichaels.
We are trying to move through this efficiently, but again, we don't do things quickly just for the sake of getting through matters.
The judge estimated it would take 2 weeks for jury selection, but the selection process has been slow, frustrating potential jurors who have to sit and wait in a room for hours, and also for the attorneys. On at least 2 days so far, court did not adjourn until close to 9 o'clock at night.
Those are long days. That's 12 hours in court, and doing that day after day is pretty taxing.
The community is also anxious. Ahmaud Arbery was killed in February 2020. 3 months later, video of the shooting was posted on YouTube, provoking a media frenzy and causing emotions to run wild across Glenn County.
What happened was not right. It's not us, and we are better than that, as you said, and we're going to get better through this.
Ahmaud Arbery's parents haven't missed a day of court. Their pain has no name, and it will never go away. But getting 3 guilty verdicts will help heal their hearts and this community. Justice delayed, but not denied, they say.
God is going to let a guilty verdict roll down out the sky.
Right. It's time to finish this jury process. Stop delaying it. Stop dragging it. It's time to start the trial.
64 qualified potential jurors have to be chosen before the next phase of jury selection can begin. Once the court reaches that 64 number, then they will have to cut it down to 16, 12 jurors and 4 alternates. After that happens, opening arguments can begin. In Brunswick, Georgia, I'm Drake Clark for Making the Case.
We have a lot to discuss with our legal panel tonight. Joining me now from San Francisco is veteran prosecutor and BNC legal contributor Paul Henderson, and in Atlanta, criminal defense attorney and vice president of the Atlanta NAACP, Gerald Griggs. Gentlemen, thanks for being with us tonight. I am so lucky to have you two brilliant legal minds help me through this. So I want to set this up for everybody first. So we talked about the strike being the theme of the day. At least 9 of the 18 prospective jurors questioned were struck for cause, many because of their close, often personal relationships with Ahmaud Arbery, his family, or the defendants, or their families. So one juror, referring to his close connection to a member of the Arbery family, said, quote, "I would call him a friend." Another, also with a close connection to the Arbery family, said reaching a verdict might ruin one of his friendships. So this has been the theme of jury selection. What do you read into all these strikes as we get closer to that magic number of 64? Paul, I'm going to start with you first. We knew it was a small town, but wow.
Yeah, it's a little shocking probably for folks outside of that community to really recognize that growing up in a small town also means that in a case like this, in a controversy like this, with stakes like this, and keep in mind at the heart of this is the conversation about race, that a lot of things get exposed. And so it seems natural to understand as people are talking about what translates as bias is coming out in the conversation about who can sit on this jury. And so when you were talking earlier about folks being stricken for cause on either side and or by the judge, that's exactly what it speaks to. The people that say that they are biased or that they do have some familiarity that interferes with their ability to listen to and or decide the case. And it probably is not helping that process along, although it increases the truthfulness and honesty there, that the family is there in the courtroom as well, along with the defendants. And so almost everyone in this pool in the small town recognizes or knows the individuals that are in that courtroom and certainly knows about the case. But really, we should be having the conversation too, so that people know what they're watching about what the standards are for cause versus the standards for preemptory challenges, as these jurors are being winnowed down into the magical 64, which will take us to the next level of analysis to determine our 16 that will sit in deciding this case.
Gerald, what do you think?
I think this is normal in any high profile case in Georgia, especially one in a small town like Brunswick. I mean, there are 84,000 people in Glenn County, so you had a 1 in 84% chance that you knew somebody associated with this case. So I don't think this is not abnormal. You know, in major high profile cases, it usually takes a month to select a jury to get down to the magical number of 64 to get to the actual peremptory strikes. These strikes for cause are because people cannot be fair or unbiased or fair and impartial in coming to the case, and they have some type of relationship with one of the parties. So this is normal. I thought the judge was being a little bit over anxious and thinking he could get this done in 2 weeks. I was leaning for more a month. We're almost on schedule for about 3 weeks. They should have 64 by the end of next week.
Oh, okay. I like your prediction. We'll see if it comes true. Well, here's what else came up. If it wasn't a personal relationship that got potential jurors struck, it was likely a fixed opinion. So during group questions, 15 of those 18 jurors, they raised their hands to say they already had formed a negative opinion of one or more of the defendants. When it came to individual questioning, we heard statements like, quote, "I personally think that they are guilty no matter what." I'm referring to the video. "It's just so ingrained in my mind, I don't think I can put it aside." Gerald, back to you. We know some of those people were struck, but some of them could make it on the jury. So how is the defense going to deal with that?
I think that's a very difficult question for the defense. And I think it goes to the thinking in the defendants. You have to listen to what's happening in jury selection, and you have to get a feel for what a jury is going to potentially be like in this case. It's going to be very difficult to prove their defense. And again, of course, you don't have to prove anything, but these jurors are already saying that they are leaning in one direction. That's why many of them were struck. But they're just voicing what others are actually feeling. You know, some people can be rehabilitated and say, yeah, based on what the judge said, I could be fair and unbiased, but they still had that preconceived notion. And then once they see the video, it's going to be very difficult. So I think this is something that the defense has to mitigate against, and it's going to be an uphill battle.
All right, so some of the potential jurors are being questioned for a half hour or more, only to be struck in the end. But I want to take a look at two people who did not get struck today. So juror 281 is a white woman. She is from another part of the state and moved to Brunswick after Arbery's death. In fact, she said that she had never heard of the case until she told people she was moving. Wow. When it comes to the news, she said, quote, "If somebody happens to share something on Facebook, I'll see the headline there. I don't actively seek out news." Juror 281 was sent back to the pool after just about 15 minutes. A similar story for juror number 282, also a white woman. She said, quote, "I wasn't here when it happened. I was on vacation. I was gone for like a month." She went on to say, quote, "I don't know if we will ever know what really happened. I think there's always two sides to everything," end quote. What might either side see in these jurors? Paul, I want you to talk about the prosecution.
Okay, so from the prosecution, that ambiguity makes me a little uncomfortable. And what I would read into those responses is that they are not aware and have not cared to investigate or look into this would be the trial of the century for that community. It just is, for so many reasons beyond just the tragedy that happened. And so I had a number of red flags that would have been raised by those comments. I wouldn't necessarily have struck them right away, but I would absolutely have more questions for them. Because if this is not something that they are familiar with, I do want to know, and I would have questions about what kind of social media, what kind of news they watch, how do they get their information, what their communities and surroundings look like to not know about this case at all. I'm not saying it's going to block them completely, but I have more questions. Because the thing that we have to remember here when we're talking about exercising strikes that are for cause is that individuals have to express something. They have to tell you something. So my job as a lawyer is to elicit responses that I can craft, shape, or argue about in order to get them to fall into that case, that category or not, or try to rehabilitate them if I need to keep them. And that bias that we keep talking about is only one of the three standards that you need in order to fall into a for cause rejection. There's a bias that could express someone not being suitable to decide a case. There's an inability to understand. And the third thing is an inability to communicate with the other jurors. And so all of those things you're trying to elicit at the same time. But obviously, in a case like this, we're really focused on the bias part. And it really is intrinsically connected to the conversation about race. That's why we're having the conversations as in depth as we are, and the process is taking as long as it's taking.
Very thorough, Paul. Okay, so Gerald, what about the defense?
These are the exact type of jurors that you need to make sure you keep them in that lane where they're saying that they can be fair and impartial, because they would lean towards your argument, or they are susceptible to your argument. So I think that these are exactly the type of jurors that you would need. Somebody that's not heard about the case, somebody that's not sought out information about the case, somebody that lives in a bubble, that's stuck their head in the sand, to not have heard about this in that small town or even in this state. So I think they're the perfect type of jurors that the defense would seek out.
All right. Well, Paul and Gerald, you have both graciously agreed to stay with us. So coming up next, we're going to talk more about how the long days and this drawn-out process could be impacting some of these jurors. So stay tight, everyone. We'll be right back. This is Making the Case. Everyone, the judge in the trial of Gregory McMichael, Travis McMichael, and William Bryan originally thought jury selection would be over by now, but it's clear after today we still have a long way to go. Back with me, I'm excited to welcome back in veteran prosecutor and BNC legal contributor Paul Henderson, and criminal defense attorney and vice president of the Atlanta NAACP, Gerald Griggs. We're having a great conversation. Gentlemen, thanks for staying with us. I want to start by talking about juror number 276, another white woman. She had a few animated exchanges with both sides. Now, we don't know if this statement was triggered by exhaustion from the long day. She might have been tired, maybe just her general feelings. But during questioning by the prosecution, this is what she said. She said, quote, "A juror can only go by the evidence you give them. So no disrespect intended. If you get a lousy verdict, it's because you gave us lousy evidence." Okay. Paul, do you have any red flags with that response? It's kind of juicy.
Absolutely. I mean, that to me says, listen, I'm going to do my job as a prosecutor. I'm going to do my job the way I know to do my job. And I'm going to present the evidence, and I'm going to present it to you in a clear, concise, and direct manner to make my arguments, and then try that evidence to the arguments that I have to make in order to allow a juror to make a decision, obviously, that leads them towards guilt. But hearing that raised, the stakes being raised so directly by the juror in a way that did not seem open, didn't seem friendly or engaging about show me what I need to do to follow the steps to get there, makes me a little uncomfortable. The only solace that I would take is feeling, though, that frustration might be shared on the other side from opposing counsel. The problem is, with myself as the prosecutor, I've got the burden. So that's a red flag for me, and I absolutely would have follow-up questions for that juror and would put a question mark by their name just based on that response.
Yeah, I'd put several question marks and exclamation marks next to that name. I want to talk about another factor in this case that we haven't gotten into very much. Juror number 181 actually brought this up yesterday. She expressed concern about the time, more than 2 months, between Ahmaud Arbery's killing and the arrests. As we have reported, the now former district attorney Jackie Johnson was indicted for misconduct last month. In questioning, juror 181 said, quote, "It should have been prosecuted differently in the beginning. I feel it was totally handled wrong." I want to hear from both of you. Do you expect that dynamic to play a role once this trial kicks into high gear? Gerald, you first.
Absolutely. You know, they're going to have to explain why it took 74 days to get to where we are right now with an indictment and these individuals standing trial. And I think that it's incumbent upon the prosecution to explain that to the jury. I think they're going to have questions about that. And you just have to be open and honest. I think that the defense can try to latch onto that, but that could be a very slippery slope and a Pandora's box because the reason why it took 74 days is a connection of both prosecutors to the two defendants that are sitting at defense counsel table. So it can cut both ways, but I think it's going to be a big cloud over this entire trial.
Paul, what do you think?
I think it's going to be a really complicated issue that the judge is going to have to intervene in. And I can't imagine that this judge is not going to limit how much information these advocates can color this case with conversations about what other people did that could be a distraction against the defendants that are here being charged in the case that's on hand. And I've said this before that the reason that Ahmaud Arbery is important and part of what makes it such a terrible tragedy beyond just the George Floyd analysis, if you compare the two, so George Floyd is a focused analysis on policing, not just what we expect police to do, but what we don't want police doing or we can't have police doing. And this case, I think, will stand for the approach of what we look at for our criminal justice system. Like, how does that expansion beyond just law enforcement? What is vigilanteism? What is the expectation from prosecution? What's the expectation from law enforcement? And so it's a step back in a broader scope of our criminal justice system that is on trial as much as these three defendants as well, because what it's exposing are some real travesties and real calls to action. And so I think the judge in this case is going to try and put some limits on how much either side can go into what should have happened and what didn't happen as a distraction to evaluating the evidence against these three specific defendants.
Yeah, shoulda, coulda, woulda. So something else that came up this week, the significance of the juror questionnaire. The defense made a point to note that some of the jurors are giving different answers and questioning than what they wrote on their questionnaire. He told the judge, quote, "We have to get on the record that the jury cards and questionnaire are truth. Otherwise, we have a real problem." Gerald, is this a common issue?
No, it's absolutely not a common issue. This is a high profile case. In most cases, you don't get a jury questionnaire. You actually have to ask the jurors the question live. And so I think that what the defense is doing is building its record on appeal because they know that this particular trial has a 75 to 85% chance of going against them. And so they're trying to build a record on appeal. You typically do not get a well versed analysis of 40 pages of questions from potential jurors ahead of the actual voir dire. You generally have to ask them the general questions and then follow up with specific questions, and you have to take notes as they're giving them. You don't have that ready-made sheet. So I think they're making their record. I think they're trying to do a good job for that because they're expecting what we all are expecting, and that's a conviction.
Yep.
So we still have around 15 more prospective jurors to select before we make it to the next round. Question for both of you. How will questions change when it's time to start whittling this down to 12 jurors and 4 alternates? And what will that process, will it make it move any quicker? Gerald, start with you first.
I think the judge is probably going to make the questions a lot tighter. I think at this point, you're playing protect the jurors that you want. So you're not going to ask as specific questions, which will point out where your opponent needs to use a strike to get that juror off. You're trying to protect potential jurors that you believe would go with your argument. So the questions will be tighter. It's going to move a lot faster. And I think we'll get to the 16 again within the 4-week time window.
All right, Paul, you next.
So I think what you're going to see is more of the questions that are focused on the evidence and this case. So you'll hear more of the questions that plays to what the trial is about to be and the evidence that they're going to see. Questions like, how do you respond to violent videos? How do you make decisions if you are faced with racism? What have you ever seen in terms of things that may come up during this trial that will be absolutely much more specific than the questions that you have been seeing that have been more general and focused on eliciting personality perspectives and approaches to decision making that we've seen thus far. That's going to be the difference. It will be much more focused and reflective of this case in particular, the facts and evidence of this trial that's coming out.
All right, a great panel, gentlemen. Thank you so much. Veteran prosecutor Paul Henderson and defense attorney Gerald Griggs. Appreciate you being with me here on this Friday night. And Gerald, I know you're going to stay with us a little longer, so hang in there.